Hello, my name is Kyle Crassa, and I'm an estate planning attorney in Pacific Grove, California. I'm certified by the State Bar of California as a legal specialist in estate planning, trust, and probate law. The purpose of this video is to give you general information about an important aspect of estate planning law so that you can be prepared when working with your own attorney. Watching this video does not establish an attorney-client relationship. The law is far more complex and nuanced than can be explained in a few short minutes. As a result, before acting on any of the information contained in this video, you should consult a competent attorney who is licensed to practice law in your community. With that understanding, I hope you enjoy my video and you find it informative. Thank you. Property tax in California is governed by Prop 13, which are rules that are unique to California. I'm not aware of any other state that has rules that are similar to California's Prop 13. And let's give you the background. What is Prop 13 all about? Well, Prop 13 came about in the 1970s, and that was a time when value of real property was increasing dramatically. So the fair market value of real property was rapidly rising. And prior to Prop 13, property tax was based upon the fair market value of property. So as the fair market value increased, so did property taxes. And proponents of Prop 13 argued that this result, because of skyrocketing property values, was forcing many Californians, especially seniors, out of their homes because they could no longer afford to keep up with the rapidly rising property taxes. So Prop 13 introduced this concept of assessed value, and that was separate and apart, or it is separate and apart from fair market value. The idea behind Prop 13 was that when you purchase real property, the value of that property pretty much will stay the same relatively for determining how much property tax you need to pay, even if the actual fair market value is increasing rapidly. So it decoupled fair market value, the actual value of the property, from assessed value, the value upon which your property taxes are based. And what Prop 13 does is it favors, even today, it favors people who hang on to their real property for a long period of time. So the longer that someone will hang on to property, the wider this gap gets between the actual fair market value and the assessed value upon which one's property taxes are based. And so for a lot of people, there's this huge gap here between the fair market value of their home and the actual assessed value that their property taxes are based upon. Now, there are certain activities, certain actions that will trigger a property tax reassessment, sometimes a full property tax reassessment or a partial property tax reassessment. The most common trigger and the most dramatic trigger is a change in ownership. So the general rule is when there is a change in ownership, the assessed value is going to pop up to the fair market value at that time. It's going to catch up to the fair market value for the new homeowner. Then that new homeowner will keep their assessed value, and they'll keep it all the way until there's another change in ownership. Then it's going to pop back up to the fair market value again. And then they'll be able to keep their value until they sell it, and then another change in ownership, it's going to pop back up. And of course, the longer that someone is held on to property, the more dramatic that jump is going to be from the assessed value to the fair market value. Now, there's one really important exception to this general rule that a change in ownership is going to result in a property tax reassessment. And keep in mind that the larger this gap, not only will there be a big jump up to the fair market value, but the property tax for that new homeowner are going to increase dramatically. So if you can keep the assessed value, you want to do that as a taxpayer. So one big exception to the general rule that a change in ownership is going to result in a property tax reassessment and therefore higher property taxes is transfers between parents and children. So the general rule is that if it's a transfer between parents and children, and if it's the principal residence of the transferor, then that residence can be transferred between parents and children or between children and parents. So it can go both directions. It can go from parents to children or from children to parents. But if it's the principal residence, it doesn't matter what the value of that property is, there will not be a property tax reassessment. So despite the change of ownership, the property tax base will stay the same. The assessed value will stay the same. If it's not the principal residence, if it's any other real property, then we can avoid a property tax reassessment as well, up to cumulatively $1 million worth of assessed value. And that's an important key here. This is assessed value, not fair market value. So that means that if you had a vacation home or commercial property or something other, a rental home, something other than the principal residence, cumulatively, when we add up all that other real property together, up to $1 million worth of assessed value can also be transferred between parents and children or children and parents without reassessing the property taxes, without increasing the property taxes. And that $1 million cap is actually a much larger cap for most people than it seems, because it's $1 million worth of assessed value and not fair market value. So if you think back to a moment ago when I had the graph of the fair market value and the assessed value, and there being this giant gap between the two, it's that lower line that's the $1 million cap. So that $1 million is actually worth a lot more than it seems. So here we have this general principle that change in ownership will trigger a reassessment for property tax purposes unless it's a transfer between parents and children. And if it's a transfer between parents and children, the principal residence does not matter what the value is. There will be no property tax reassessment for property other than the principal residence. You'll avoid a property tax reassessment as long as the cumulative value is $1 million worth of assessed value or less. So let's think about this in the estate planning context, because we have to be very mindful of these rules, and we have to know how to navigate these principles when we think about estate planning. And this could work for lifetime gifts, gifts while the parents and children are both living, or gifts upon death. So let's assume that we have some parents here that have some real property, and let's assume that they decide they only have one child. So they give everything they have, including, though they might have other assets, but including real property, they give everything they have to their one child 100%. Well, in that case, we know that the parent-child exclusion will apply, because clearly that's a transfer between a parent and a child. So when it's the principal residence, no matter what the value is, there's not going to be any reassessment in that case because it's a transfer between a parent and child. If it's any real property other than the personal residence, well, then there's $1 million worth of assessed value that can be transferred. And if you've hung on to real property for a long time, if the parents had hung on to property for a real long time, the chances are that that other real property is going to be worth less than $1 million of assessed value. So in that simple situation, we know everything is going to be just fine. Let's change the facts a little bit, and let's assume that the parents have 2 kids instead of 1. So we're going to say child number 1 and child number 2. But let's assume that the parents decide in their estate plan, in their trust, or in their will, that they're going to identify a particular house, and they're going to say, even though we have 2 kids, we want to give 100% of our house to child number 1. Well, in that case, everything would be fine from the property tax perspective, because again, the parents are making a choice to transfer their real property to child number 1. And that's clearly going to be a transfer between a parent and a child, and there's not going to be any reassessment for the principal residence or for any other real property that has $1 million of assessed value or less, cumulatively $1 million or less. Let's change the facts a little bit, though, and let's assume instead that the parents say, well, whatever we have, including our house, we want it to go 50-50 to our two kids. We want child number 1 to have half, and we want child number 2 to have half. Here's where it can get a little tricky. Well, first of all, let's keep things a little simple. Let's assume that child number 1 and child number 2 say, you know what? We both like the house. We're going to keep the house. We're going to be co-owners of the house. So 50% of the house can be transferred to child number 1. 50% of the house is transferred to child number 2. Both child number 1 and child number 2 are on the deed as 50-50 owners. They're going to decide how they're going to use that property. Maybe they'll share it as a vacation home. Maybe they'll rent it out and split the proceeds. Whatever arrangement they want to make, they agree to hold title 50-50. Well, in that case, everything's okay because half of the house came from the parents to child number 1, and half of the house came from the parents to child number 2. Each half is a transfer from a parent to a child, so the parent-child exclusion applies. Everything works just fine. If it's the principal residence, there's not going to be any reassessment in real property. For any other real property other than the principal residence, as long as the cumulative value of all that other real property is $1 million of assessed value or less, everything's going to be just fine. But let's think now that there's a situation where the kids don't want to be 50-50 owners. And child number 1 says, you know what, I would really like to have that house. And child number 2 says, well, that's fine. I don't want the house. So now we have to be careful because we want to really make sure that if 100% of the house is going to go to child number 1 as part of his or her 50%, we have to make sure that the assessor is going to view that entire transfer as a transfer between parents and children. We don't want, and in that case, if there are enough other assets in the estate where we can equalize the distribution, we can give those other assets to child number 2 so that at the end of the day, both child number 1 and child number 2 have an equal share in the value of the estate, then everything is just fine. This is referred to as a non-pro-rata transfer. California Probate Code allows that. A lot of estate plans will allow that as well. And what that just means is that instead of taking a line and drawing it down the middle of each asset, we're taking a look at the total value of the estate, and we can give 100% of some assets to one child and 100% of other assets to another child, as long as at the end of the day, each child gets an equal share. Because if the trust demands 50-50 split and both kids end up with 50-50 of the value, that's fine. The assessor doesn't care that only one child ended up with 100% of the house, as long as the terms of the trust requiring 50-50 split of the total trust assets were met, and the other child was given enough other assets to equalize the distribution, then everything would be fine. The assessor would still view this transfer of the house 100% to child number 1 as a transfer completely from the parents to the child, and the parent-child exclusion will apply. Now, where it can get complicated is, what if there aren't enough other assets to equalize the distribution? What if the house was the only asset? A lot of times in California, real property is the most valuable asset, and sometimes the residence is the only asset of substantial value for the estate. So let's assume that situation, where the only asset or the only significant asset of the parent's estate was the house. The trust mandates a 50-50 split here, but one child wants to keep the house and the other child wants to cash in. They want their money. They want cash. So we have to be very, very careful here, because if child number 1 says, okay, I'm going to take 100% of the house and I will give my sibling enough money to equalize the distribution, now we have a problem. Because the assessor's going to say, you know what? Half of the house came from a parent to child number one, but the other half of the house really came from the other sibling in exchange for some cash. It's really a half transfer from parents to child number one and a half transfer from child number two to child number one. There is no sibling to sibling exception for Prop 13 and in order to maintain Prop 13, and so there will be a 50% reassessment. There will be a 50% reassessment on the share that would have belonged to child number two. That will dramatically increase the property taxes for child number one, and that would not be an ideal situation. So what can be done here? Well, there are two options. One option is if there is special language in the estate plan that allows child number one to basically buy from the trust the other share. So if there's special language in the trust that says child number one can put money in to the estate or into the trust, and then the trust can turn around and give that money back over to child number two, then we're okay. So if there's special language in the trust, we're okay. Child number one can do that pretty easily. Problem is, a lot of trusts don't have that special language. So without that special language, now we're kind of stuck. But there's one more option, and that's an important option. That one option is that while the property is still in the parent's trust or in their estate, the trust or the estate get a loan from a third party to cover the difference. That money cannot come from child number one. It cannot come from the child who is taking the property. It has to come from some third party. So if, while the title to the home is still in the parent's trust or the parent's estate, and the trustee or the executor gets a loan from a third party who is not child number one, then and the proceeds from the loan come into the estate or the trust, then the trustee can distribute 100% of the house to child number one, and the cash subject to the mortgage, and the cash to child number two, and equalize that distribution. Now, the problem here, a couple of problems and a couple of traps for the unwary. Number one, you have to do this before title exits the trust or exits the estate. You cannot transfer title to the house to child number one and then get the loan. It has to happen while the house is still titled to the parent's trust or the parent's estate. So that's number one. Number two, it is hard to find a lender who is willing to make that kind of loan. Most lenders are going to require that the property be in child number one's name first, and that's going to blow the property tax exemption, the parent-child exclusion. So there are a few lenders. There are specialized lenders. Those loans are usually more expensive or they're always more expensive than your average lender, but there are certain lenders in California who understand these rules and will lend in that situation. But there are not a lot of lenders who handle it, and it's a more expensive loan than typical, but it's worth it because it will save substantial property taxes. So it's very important to be careful in this situation. A lot of times when parents pass away and the children are trying to figure this out, they feel that they can sometimes do this without the guidance of an estate planning attorney, and these are nuances and traps for the unwary that they're going to fall into if they don't have proper guidance from an estate planning attorney. This is definitely not something that anyone should try to handle on their own because it's such a complex idea. But this just gives you some general information. I think the bottom line, the takeaway here is, number one, consult an attorney to help you with this. But probably the bigger picture is that there are ways that you can navigate these different issues about transferring real property to one child and letting the other child take some cash or other assets to satisfy their share. And there are ways to do it that will blow the parent-child exemption, and there are ways to do it that will preserve the parent-child exemption. And I think it's important to keep that in mind so you know to reach out to a qualified competent licensed attorney to help you guide you through this process. I hope you enjoyed watching my video. As I mentioned at the beginning, this is not intended to be a substitute for proper legal counsel. Before acting on any of the information contained in this video, you should consult a competent attorney who is licensed to practice law in your community. Thank you.